Is there any responsibility within DOT here?
Well, that's not something for me to answer, Steph, either now or down the road. Look, I think like any state agency, I run one. I've run a federal agency. Issues about performance, hi Patrick, issues about performance, are separate from a lawsuit, which is what we're involved in here. I also want to point out that the work done by Mr. Savage and Mr. Listow and his team is extraordinary, and was very helpful once we joined the team to have a lot of information at our disposal so that we could get on the same page with them very quickly and develop the complaint as it exists today. They can't be with us today because they weren't expecting there to be press availability. The team collectively decided that a press release was the way to go here, but I've done enough things over the course of my career that I knew that there would be questions, and so we fit this into my schedule today.
Liechtenstein, that report from 1992, in the complaint that's put out here in the lawsuit, it says that they made a prediction about the tie-down rods. Ultimately, it was unlikely that the cracks in the post-tension cantilever beams would continue to grow as future inspections later revealed, however, that prediction was wrong. Do we know why Liechtenstein was not named in this lawsuit?
Yes, I know why, but I don't want to get into the details of that. But there are a lot of things that go into the consideration of who to sue, and these are the parties that we felt were appropriate to bring a lawsuit against at this time. Now, look, over the course, this is civil litigation, which is very different from what you might see typically coming out of this office. I mean, obviously we're prosecutors, and we know our facts before we bring a prosecution, an indictment, or an information. Much of the consumer and healthcare work that we do when we're bringing actions there, or making regulatory decisions there, or if we have to go to court there, antitrust, for example, we have the ability to get information before we bring a complaint. This is traditional civil litigation where facts are fleshed out in discovery, and that'll be the next thing that happens here. And so as those facts get fleshed out, we'll know a lot more about our own claims, frankly, and about whether or not there are other parties that should be involved in this lawsuit or not. But that's how typical civil litigation works.
Are you going to be filing more lawsuits in regards to the Washington Bridge?
I really can't say right now.
Based on this lawsuit, is each company sharing the same amount of responsibility, or is there any indication that one company maybe holds more responsibility than the others?
It's way too soon to know that, Gabrielle. Civil litigation of this type involves, the first instance is establishing culpability, and then if you establish culpability, then you establish damages and apportionment among parties for damages. And so way too early to get into that. I mean, this is really the beginning of what I expect will be a really long road ahead. And so I think it's too early to talk about the extent of any potential recovery and who might ultimately be responsible for it and who might be jointly or severally liable for it.
So what are the next steps in this long road ahead then?
Yeah, so it's like any civil litigation, which I've done and overseen here and at the U.S. Attorney's Office and did when I was in private practice in Boston. So when anyone, whether it be the government, as is happening here, or a private party files a complaint, the next steps are a response from whoever's been sued. And so every one of those defendants will have to respond to our complaint. There are two ways to respond. One is with an answer, one is with a motion to dismiss. So it's either motion practice going forward or there's an answer where they either admit the allegations against them or they deny them, or they admit some and deny others. And then after that, there's discovery. So interrogatories, requests for production of documents, requests for admissions, among other things, depositions for sure, potentially, and then there's usually motion practice after that, and then And then when that motion practice is done, there's trial. And so that's how any typical civil case plays out. So all those steps take a lot of time. So, that's when I say there's a long road ahead of us, that's what I mean. The long road is all of those steps, which ultimately lead to a civil trial.
And how long do defendants have then to respond to this suit?
It depends on a lot of things, including, where and when service is accepted. Typically under most rules, it's a matter of, it's less than a month, but it could be a little bit longer than that. But it's not months and months out.
What's your message to Rhode Islanders? There's been a lot of confusion. People have been waiting for this. What would you like to say to people?
Well, what I would say to them is that I don't know exactly what confusion you're referring to, but I can tell them this: the case is in very good hands. As I've said many times, Mr. Savage, Mr. Wistow, and their team, this group of great lawyers, I've assigned to really outstanding lawyers from this office to work with them. Stephen Pravazza, who runs our consumer protection unit and does a lot of outstanding work for us on significant cases. For example, he handled the antitrust work in the proposed merger between Lifespan and Care New England. And I don't know that there's any more complicated area of the law than antitrust, and Stephen handled that. He's done a number of really outstanding consumer cases with his team. And then Sarah Rice is the deputy chief of our civil division, heads our public protection bureau. Another outstanding lawyer has argued some really significant cases for us. Another place, and among them, the Supreme Court, the Block Island case involving Champlin. She's defended our high-capacity magazine case. She handled our litigation involving the sale of Narragansett Electric from National Grid to PPL. So Steve and Sarah are outstanding lawyers, and so I think what the residents of Rhode Island should take from that is the team, both our lawyers and the team hired by the governor, now retained by us. This case is in really strong hands.
Can you just explain if 5 different companies that have expertise in inspecting bridges inspected the bridge from 2015 to 2023, and every single one of them missed these problems, how is that negligence versus there's something wrong with the design of the bridge that caused all of these different companies to miss the problems?
Well, I mean, I don't want to try the case here, and I'm not going to do that. But I think if you read the complaint, experts are hired for a reason. It's for their expertise. And when original plans exist, as alleged in the complaint, and the contract provides that those plans will be reviewed, and allegedly they're not, or they're not reviewed adequately, then I think that's how one might conclude that there might be a negligence allegation against those companies.
And again, there's all this talk of the original design being flawed. Why didn't you sue McGuire and Associates, the company that designed the bridge?
Yeah, so again, I'm not going to get into why some entities were sued and others weren't. There are lots of things that go into bringing a lawsuit, including things like the statute of limitations, although I don't want to get into that in any great detail. But I will tell you that every conceivable potentially responsible party was evaluated by the litigation team. And at this point, the ones that we believe a lawsuit should be brought against have been sued.
What is the statute of limitations for this type of case?
Yeah, I don't want to get into that because we got a lot. We have 13 defendants here, and I'm not going to, forecast, the relevant law or any relevant potential defenses for them. I mean, I'm sure these companies will hire counsel and we'll move forward from there. But I will say that I have a lot of confidence in these lawyers, and when I studied the complaint, as I did over the last several days, I have no doubt that they have analyzed this case the right way.
How does Cardiff Court fall into all of this?
Well, that remains to be seen. I mean, that's why there will be, to the extent the public sees it, and certainly any kind of motion practice will be public, because it'll be in an open courtroom. I mean, all these things are going to play out over time. I mean, the answers aren't all there yet, and they're not ready to be shared with the public yet. But because there's litigation, and that litigation has to be protected, and the defendants in this case, they have a right to defend the claims against them, and it's important that we remember that and we talk about what we allege, and they'll have a chance to answer as I've already discussed, respond more accurately.
And their situation, they're largely resolved at this point. I guess my curiosity is what's going to be, the retribution that the state would be hoping to seek in that situation.
Well, we don't seek retribution, although I know you're not a lawyer.
Yeah.
I suspect you're not.
Did you not
It's okay.
sue them because they went bankrupt and there was
No, not necessarily, Steph. I mean, certainly, there are lots of bankrupt entities that get sued. I think Purdue Pharma, for example. So, again, I don't want to get into all those decision makings in the decision making tree. All I can tell you is that I know that these issues have been analyzed. For right now, the appropriate companies are in that lawsuit.
So this, obviously no state officials or entities are named. They were the ones who hired all these companies, gave them their marching orders. Do you think it looks strange to the public to have the entity that was responsible for the bridge, owned the bridge, hired all the companies to not be subject to any of these accusations and essentially blame all of the private parties who worked for the
Sure.
state for it?
So let me try to give you an analogy, and perhaps you can help me answer that question. So let's say you and I own a house together, and we hire a contractor to redesign and redevelop our house, and that contractor hires subcontractors, plumbers, electricians, roofers, and you and I don't know a darn thing about building a house. You and I, Patrick, can't go out and build a house, plumb it, put the electrical in. And so the contractor and the subs go ahead and build this house. And when you and I move in, the water doesn't work, the sewer doesn't work, the lights don't come on, the roof leaks, and the chimney doesn't draw the way it should. When we build a fire, we get a lot of smoke back in the house. Now, the person ultimately responsible, I would argue, in that situation, not you and I, we hired these companies for their expertise. We depend on them to provide their expertise. And when they don't do it, we try to hold them accountable. Your consumer unit, Steve, does that, I think, on a relatively daily basis. And so that is the analogy that I would provide to you. Whether or not someone should have overseen the experts differently is not a matter for us to discuss here. What we're talking about here, what we allege in this complaint, is that the state relied on the expertise of these companies. That's how they hold themselves out when they bid on a job, that they are experts, that this is something that they know. This is not unusual. This happens all across this country and around the world every single day. So that's what this case is about. Was the state entitled to rely on the expertise of these companies, and did they provide the requisite expertise that they promised to provide? That's the question here. We allege that they didn't, and that's why we brought the lawsuit.
Do you think that whatever you recover, the state will end up just paying those costs on the back end, because contractors who are thinking about next bridge project, highway project, will see this and say, well, something's going to go wrong, and we're going to get sued, so we're going to add 20% to our bids, or we're not going to bid, as has been the case with the last couple of contracts for DOT.
Yeah, look, I'm not going to engage in that kind of speculation. Again, I know that we bring lawsuits against contractors in the example that I gave to you time and time again. We've done sweeps where we've done 19, 20 at a time. That doesn't mean that nobody's building houses in the state of Rhode Island. So no, this is a lawsuit. I'm a lawyer. This is what we do. We believe that this lawsuit's appropriate and justified, and that's why we are bringing it on behalf of the state, working with Mr. Savage, Mr. Wistow, and his team.
Kind of going off of that, the list is a who's who of who builds infrastructure in Rhode Island, and at this point, I'm sure a number of them have active contracts at this point. Does this lawsuit, in your opinion, affect any other contracts?
Yeah, I really can't talk about that. If the point of your question is we'll never find anyone to build a bridge, I don't think that's very likely. I think we'll get a bridge built. All right. Anything else?
Is this just on a surface level looks kind of like the 38 Studios game plan lawsuit? Is that a apt analogy, or is it very different from the approach that was used in 38 Studios?
I don't know what approach was used there. I wasn't involved in that.
To just sue whoever you could and then take it from there.
Well, no, I don't think that's an apt characterization. Your colleagues have already asked why we didn't sue at least two parties that were involved. So we haven't sued everyone. I mean, that's plain from the questions that your colleagues have asked,
Well,
Patrick.
you haven't said why. You didn't sue.
Well, I don't have to say why,
I know,
right?
So how would we know?
Well, but you said we sued everybody. And they asked, well, hold on a minute. You asked the question. Let me finish it, Patrick. They said, why didn't you sue party? So we didn't sue everybody. So no, I don't accept the analogy. And frankly, it's an insult to the office and Mr. Savage and Mr. Wistow. That's not how we work here. In fact, it violates the rules, the professional responsibility rules against filing frivolous lawsuits. We sue companies that, in our view, deserve to be sued based on the law and the facts. And that's what we've done here. So there's no game plan that we followed other than we sue people based on the law and the facts.
Would you elaborate on the ways that it's different from the 30s? Setting aside
38 Studios is irrelevant to me. I don't care about it. I wasn't involved in it. I didn't think about it for 1 minute. What I thought about was whether the complaint that was worked on by the team when I saw it, there was a basis for suing the people involved, the companies involved, and whether the facts and the law led us there. That's the decision-making process. It's not different from any other work that we do. I don't care who did what in 38 Studios is irrelevant. Relevant to me.
How much money do you think you're gonna get?
I don't know, Steph. As much as possible.
Millions, tens of millions?
I don't know. Anything else? All right. Good to see you all. Thank you. Have a great weekend. Thanks, team. Good work.